House Public Safety Homeland Security Committee. We have two bills on the agenda today. First off, we're going to call up Senate Bill 23. If I might ask, could everybody cut your cell phone off? If not, be prepared to make a $100 donation to whatever charity you want to.
Prohibits the minimum waiting period for initiating a missing persons report. Missing person may be incapacitated due to a serious medical condition, and it also authorizes a statewide endangered person advisory on a missing person with severe medical condition. And I know you all know that we already have a MEDIS call, but this will have to be this will be included in there. Also, the law enforcement has indicated that the more information you have on a missing person, that helps to find the person. And so we feel that this may save lives if at the time of registration of a motor vehicle, the person can provide an alternative telephone number or the emergency telephone number, and we just feel that this will help save a life. So we are confident this will help save lives. The law is named, the bill is named in honor of Stacey Nicole English, a promising young lady, 36 years old. She lived alone at a condo in Buckhead, and went missing a couple of days after Christmas in 2011. Her car was found in the middle of the night, car in the ignition, the car running, but she was not there. And law enforcement tried to locate her at her home, tried calling her home, but she was not there because she was missing. She had a severe medical condition. And her body was found about a mile from where her car was found about 3 weeks later. And actually, we are both these precincts there. And I wrote about that the other day. Her parents, her mother, Miss Cindy Jameson, and her stepfather, Reverend Jameson, had come to the Senate committee meeting to testify about this. But if we do not have a minimum waiting period, we just feel that that will save lives if they can start looking for it right away.
Very good. All right, do we have any questions from the committee members? This is an unusually passive crowd today. Senator, if you might step aside, I want to see if anyone else wishes to testify. All right, since there's no questions from any of the committee at this point, is there anyone here who wishes to be heard on this bill, either for or against? Am I under the impression that nobody really came to look at this bill today? Do we have, I see Terry Norris for the Sheriff's Association. Terry, have you had a chance to look at this? Very good. Do we have anyone from Public Safety? No mandates, just good common sense? Very good. Now, is there anyone else? All right, at this time, what's the pleasure of the committee? Oh, I'm sorry, we do have a light.
Answer my question.
All right. We don't have a question. All right, so what's the pleasure of the committee? We have a motion. We have a second. Have a motion and a second. Now, last call. Anyone wishes to be heard? Very good. Senator, you did a good job. All in favor, say aye. Aye. Opposed? Your bill has moved on to the Senate, to the House Rules Committee. Thank you, Senator. Senator, have you thought Senator Davenport, have you thought about maybe giving lessons over to some of your members about how to pass bills? Good to have you with us today. All right, ladies and gentlemen, before we start on the next issue, there's a few people I see out there that need to be recognized. I see Judge Lawton Stevens, former member of the House. Judge, good to have you here today. And the most distinguished Rules Chairman, Chairman Meadows. Always good to see you, friend. That being said, we're going to move on to Senate Bill 101.
Sounds like a great idea. How y'all doing today? Excited to be with you, but I'm kind of disappointed. I don't see a chair up here for me, and y'all might want to keep me here for a little longer than Senator Davenport, although she did a great job with her bill.
Senator, we had hearings on your bill last week, as you know, for testimony. And so we have your bill, and I understand that you're going to offer a committee substitute.
Yes, sir.
You have a substitute, and there's also another substitute
I understand there may be, Mr. Chairman.
to be offered.
Aren't we subbing a lot these days?
So would you like to speak on LC
3004S?
That is correct to the members.
Yes, sir, Mr. Chairman. Said they, and actually I could pick on our fine folks at Legislative Council since Ms. Long is here today. Said she listened very intently to some of our discussion on the Senate Bill 101 and some of, as they say, the perfecting that the committee worked on the last week. And I would draw your attention to page 4 on lines 124 through 126, and I'll leave it to our I won't say our former Marine, but our Marine, the Representative Atwood, on his corrections to the bill. I hope that meets with his likings on the verbiage that she's placed in there to address the honorable discharge of those in the military service. And I don't, right off the top of my head, Ms. Long, I don't remember any other changes that.
We did add changes to the section, the initial section 4, lines 105 through 117, again to attempt to address some of the issues raised in the committee meeting, particularly concerning the databases, to allow local jurisdictions to have databases. That would include any court or circuit, to allow them to communicate and have their own internal databases, but still restrict the statewide databases. And also clarifying what information can be released and under what circumstances it can be released there on 111. And then finally, the suggestion was made to make the improper release a misdemeanor at lines 116. So those were all just responses to suggestions from the committee.
Thank you, Ms. Long. Now, the LC 353004 is not substantially changed from the perfections that y'all made last week. One of the things that I'm not sure where you want to go, Mr. Chairman, but your aide has given me a copy of a much longer substitute that somebody has, and I'm not sure where we want to go to marry these two.
Well, what we're going to see if there's any questions on your substitute at this point, and then we're going to bring up the other substitute. Any questions of Senator Ginn? Mr. Atwood.
Senator, and I apologize to you, I should have gotten with you, and I didn't. We had some offline conversations with several former military folk, and it was a general consensus on line 125 that there were possible problems with the general. Absolutely none with honorable, absolutely none. And that would be the only concern that I have, and I should have gotten with you, and I failed to do that.
I'm amenable to how you'd like to have that language addressed, if there's any change you want to make.
Good. Any other questions from the committee members? All right. If not, Senator, if you might stay handy.
I'll rest over here in the window, sir.
You're quite welcome. Representative Jaspers. There's another substitute that is being offered. This will be LC 295662 ERS. If you might just go into what this substitute is.
Okay, thank you, committee, and I certainly want to thank Legislative Council and Mrs. Long, Ms. Travis for working a lot the last couple of weeks with this. The sub you see is House Bill 512 with some additions of Senate Bill 101 in it, and it's going to kind of go through the changes we made. My line number's off a little bit. The sub didn't come. I did this morning, so my lines are off a little bit. But we changed a number of things in 512 that you need to know about. The key thing around on line 74 is it's now an opt-in for places of worship. It was taken out of the code, so they would have to make a choice, but now it is an opt-in. Around on line 81, it's on bar carry. We're returning it to the current law. And that is where a bar owner can decide on their own choice whether or not a license holder can come in or not. Around on line 112, where we're talking about government buildings. I'll give you a second to get there. Okay, we removed the word courthouse from 512 to prevent really miscommunication. Because as you will know, all courthouses have a security plan that's directed by the sheriff in those communities, and we certainly didn't want to have the word courthouse in that part of the section where a license holder may think they could enter in a courthouse when they surely cannot. And it's really what the Sheriff's Association and judges sure made me understand that, made it clear that we certainly did not want that to happen. Around on line 226, we'll talk about campus carry. It says a 19 by it. Okay, that is remaining the same as campus carry for public colleges. We're limiting license holders that they cannot go to athletic sporting events, student houses, fraternity and sorority houses. Right below it, you'll see 20, and that's where we distinctly and clearly talk about private colleges. So there'll be no question that we're doing nothing to infringe upon the private colleges and their president's ability to make any policy related to weapons. We're making it very clear that private's private. In round 293, this is from 101. We have cleaned that information up. Also, one that everyone would be glad, that was section L. That was the credible threat. It is out of 512, and I know that's when we had most discussion about. Around 358, we're talking about probate judges and reporting there. And it's going to clarify the hearings that if they deny someone a license, they have to have a hearing within 30 days. Puts a little time limit on it to keep this thing moving along so people can move on with their lives. And it also puts a reporting time limit. It's back, very far in the back in 601, where it asks the probate judge, or doesn't ask, but tells them that they need within 30 days to report any involuntary treatment to GCIC. Okay, and that's essentially it, Mr. Chairman. And there's lots of little word differences here and there, but those are the biggies.
Any questions from the committee? Mr. Hightower.
I appreciate you bringing this up for us today. Wasn't there a section in the one before that dealt with law enforcement and when they heard?
That's the credible threat.
Yeah, that was taken out, correct?
Yes, sir, absolutely.
All right, where
All relationships to it are
Okay.
out.
Where was that at? Just at point, do you know? Or but it's,
Right off-
I don't see it in here, so, and I know you were talking about taking
We
it out.
took it out.
Okay.
It's evaporated.
Gone.
Part of the process.
Both parts of it are gone.
Thank you for that.
Yes, sir.
Mr. Atwood.
Representative Jaspers, I had a phone call from a Superior Court judge driving up.
Yes, sir.
And one of my judges. We have a very long circuit in the Brunswick Judicial Circuit covering several counties, and some of our counties do not have security unless the judge is there. And he expressed a concern, frankly, I hadn't thought about, and maybe you have, and maybe it's something you want to address on down the line, not necessarily here, but I'll throw it out to you, that someone could come in and stash a weapon while the building is empty, and then during court day, when the judge is there, come in and find it. He was very concerned about the emotional, especially more so than murder cases and that sort of thing, divorce cases, fighting over children, and all the emotion that goes on with that. I did not realize in my own circuit that we have courthouses that sometimes are protected and sometimes are not. And so I thought I promised him that I would at least throw that out to the author of the bill and get your thoughts on it and maybe have offline conversations with you as you progress on down the line.
Yes, sir, I'd like to. From the way I understand it, and Mr. Norris might could even add to it, in that every courthouse that does that has a security plan.
Mm-hmm, they do.
And it's something we mandated a few years ago, and I'm sure the wisdom of the judges and the sheriffs throughout the state are taking that into consideration. But, Terry, would you have to add anything to that?
Each sheriff is responsible for developing a comprehensive security plan for the courthouse and its annexes. And that courthouse security plan is approved, submitted to the chief superior court judge, of which that judge approves. Now, obviously, throughout the state, every courthouse is not secured at every minute. And a lot of times that's based on cost. In some places, some of the small rural areas, there's not somebody there simply because there's not a deputy that's available to go in there. And their courthouse security plan should reflect that. That's the reason it's provided in that manner.
I see. So what I look at, one more if I may, Mr. Chairman. So when I say the building is not restricted, that would be covered by the security plan. Is that what you're saying, or am I misreading that? I'm just trying to wrap my brain around it.
We're talking about government buildings because
That's correct.
Representative, you're talking about
Courthouses.
courthouses, courtrooms.
Yeah.
They're prohibited spaces.
Okay, and that's somewhere else in the bill that apart
Yeah, if you
from
look
this
back
section.
on, I know exactly on yours, it'll be on the previous page.
Okay.
If you look, it's under B,
Okay.
yeah, line 72, in a courthouse.
Gotcha. Thank you. That's all I needed.
Yes, sir.
Good. Further questions? Further questions from any of the committee? All right. So then let me be sure. I'm sorry, we do have a question. Mr. Holcomb.
Thank you, Mr. Chairman. What's the position of the Board of Regents and the Chancellor and the college presidents with respect to this new version of SB 101?
They have sent us a, I don't know what the right word, resolution, I think representative would be the appropriate word, signed by every university president and technical college president opposing it.
Okay, thanks.
No change in their attitude.
None.
All right. Further questions?
Mr. Chairman, if I might ask a question.
Yes, sir, Senator.
I'm not sure when I look at the government building on line 71 and the way that this could be addressed. I looked at the University System of Georgia. Pretty sure each one of those buildings is a government building.
think that is current wording of law, but if you'll also look also in the same current wording of law that it specifically forbids in other areas, and that's the areas that we're changing. And I will refer to counsel if he wants to add to that. Ms. Long?
As I understand it, as long as they're not having a security guard at the door, there would not be an issue with respect to carrying it into the government building. But if they have a security guard posted screening, just like any other government building that has such, it would be prohibited even in a university system, the way I read this. It's my understanding that most school buildings do not have security personnel standing at the doorway.
And I'll find out, Senator, just to make sure and get back with the committee and let them know how
I'm
that
sure if
stands.
this bill makes it over there, that'll be scratched around a little bit. All right. Other questions? Other questions from the committee? All right. You did a good job, just like the senator.
Thank you.
I would advise maybe you just join him in the windowsill over there, just in case that other questions come up. Now, at this point, the chair is going to recognize anyone who wishes to speak on this, and I would please caution you that while this committee chair is a strong believer in the First Amendment, we've had hearings on this before, so if we could keep it as succinct as we could. Yes, ma'am. Please do.
Well, first of all, I'd like to thank you very much for letting me speak. And may I add that I'm nervous. I've never done this before. But it's something I'm very passionate about. I'm here with a group of women, and there's a lot more out there. There's thousands of us, millions of us, who don't think more guns and loosening our guns is the answer. Several of you talked about emotion goes on in the world, and that's exactly right. There's emotion in classrooms, among students who get upset with their teachers and are disgruntled and could pull a weapon on a teacher, or a weapon could go off. That happens in all walks of life. If I was a teacher in a public college, I would be very concerned about that. I have a son who's a freshman at Georgia State. I'm very concerned about him walking around on a campus with other children, and he's 18, so he's pretty much from a maturity level a child amongst other people with guns. So that's a huge thing. We do not fundamentally believe that guns are safe in public places. People are emotional. People aren't well trained. And you just can't legislate it, and you cannot control emotional people with guns. We also firmly believe that guns don't belong in our schools. We fundamentally don't think that anything would have changed at Sandy Hook if someone had had a weapon. In fact, it could have been worse. So we are grieving mothers of those mothers at Sandy Hook, and that's why we stand here today. And we cannot and will not accept that that is a viable option for our country, and that is the way. And we'd also like to speak to the part of SB 101 about the 18 to 21-year-olds. Again, as a mom of an 18-year-old who has immature moments, and yes, they go off to the military, but I have nephews who are still a bit immature from 18 to 21, and and allowing a discharge, any kind of discharge, someone to get a concealed weapon. The bill, as it stands right now, and I'm not sure what the changes have been but as it stands right now, the only stopping point is an honorary discharge. Well, there are many other kinds of discharges that could cause concern, other than honorable and dishonorable, where the military has seen forth to discharge someone in not the best circumstances. We also know that 1 in 5 of our returning veterans from Afghanistan and Iraq are suffering from post-stress disorder. That is a huge concern. 1 in 5, and that 20% of our veterans returning are suicide victims, represent of all suicide victims, 20% are returning military. So there are so many reasons why we and again, I'm emotional about this. Our group is emotional about this. There are so many reasons why we oppose this, and in fact want common sense for guns. We believe in the Second Amendment. We believe in your right to carry a weapon, but not when it comes into the space that I'm in. So thank you very much for the time.
You have some questions? There's some questions.
Yes, in particular, a question about how you changed the discharge, the military discharge from SB 101.
No, ma'am. We have a committee member that wishes to ask you a question.
Oh, I'm sorry.
Mr. Hightower. You're waving? He waves.
Okay, I'm sorry. I didn't understand the process. Anything else?
Any other questions? Thank you, ma'am. We appreciate it. Do we have anyone else who wishes to testify?
Good day, Mr. Chairman, members of the committee. Again, I'm Todd Edwards. I represent the Association of County Commissioners of Georgia. ACCG does not have a position on whether or not guns should be carried on government buildings. Let me start off by commending the committee, the substitute version that's before you for consideration, by striking courthouses. That certainly was a concern of judges, of counties, and sheriffs and other local law enforcement agencies. Our one and only remaining issue on the bill is not for or against guns being allowed in government buildings, but we do believe that decision should be left up to local officials, those elected by and held accountable to the public, on whether or not they should be allowed in. The reason being is many of our county commissioners meet in buildings that aren't in fact courthouses. There are emotional decisions, as was brought up earlier, on land use, zoning, animal rights, you name it. They're very emotional, and security is a very big concern for our elected officials in those meetings. Oftentimes in rural Georgia, these government buildings don't have security at the front desk. It was told to me, and I spoke with you regarding ingress to a building. I've mentioned to some of y'all in the response to many were, well, now they can do it. It would be an added cost, of course, to taxpayers. That would be a decision they would have to make. I mean, in the interest of brevity, of which I know this chairman has a keen interest in, I'll sum up my comments by reiterating the fact that I do believe this decision is best made by local governments, their security, their constitutional officers, and what works best for their community they're elected by and held accountable to. With that, Mr. Chairman, I'll be happy to answer any questions.
Questions? Do we have any questions for Todd with ACCG? As usual, you have just done an outstanding job. It must be the silk stockings you've been.
I'm sure I swayed many of the votes of the committee today, sir.
Now, I might ask, though, in this bill, it also says that in these government buildings, if they have security, so I would say that these same county commissioners could provide security in these government buildings, which would mute anyone bringing a weapon in.
In such circumstances, I'm sure they'll be raising property taxes to do so, sir.
Or if in some of the counties I know of, the commissioners have a gun, and if they don't, they usually issue one.
That could also very well be the case, Mr. Chairman.
Good to see you, Todd.
Thank you, sir.
Yes, ma'am, I see a hand. Please come forward.
Hi, I'm Betsy Rivard, and I wanted to kind of reiterate the question we still didn't understand about the honorable versus the dishonorable, since we were not provided copies of the substitutes, so we have no idea what we're talking about. But I also wanted to know about opt-in for places of worship. I don't really know what that means. Do the ones that choose not to have guns have to put up a sign, or do the people that want to have guns have to put up a sign? Is there a standard sign, standard size? What do they look like? How will people know when they come to a church whether guns are allowed or not?
We'll let the author answer your question on the opt-out.
No, opt-in.
Opt-in provision.
You know, the current law, there will be off limits. And then so if a church wanted to, the congregation, I assume, would vote, or the leadership would, and then they'd have to say they opt in, that they are going to allow weapons in their place of worship.
How do people that are coming to the church know whether their guns
Would
there
be
or
their
not?
responsibility to inform them.
How?
Up to their choice. It's a private property.
So you could come up to the property and not know one way or the other whether you are allowed to carry your gun or not.
But I hope if they opted in, they would use their good sense.
It seems
and
like they would be required to inform you of that. You're not putting that in the bill at all.
No, if there's their private property, they will inform you if they opt in.
In what way?
It's up to them.
And I'm a visitor. I'm coming to a church and I don't know. How do I know?
Like I said, ma'am, they will, if they opt in, they will notify. They'll have a sign of their choice, however they want to.
I believe we have some others that might wish to. Mr. Hightower?
Yes, sir. In this type of provision, you'd have a church that's taking an active step in opting in, okay? So that church, by doing that, they would have had to come to their board and they'd had to opt in. They'd had to take action to allow this to happen. So in your scenario, you're worried, your question is, well, how would I know if I just walk up to this church and they don't have anything posted, they don't let anybody know? I can't guarantee it, but my common sense tries to overcomes my legal mind sometimes, and sometimes it's good, sometimes it's bad. But if you have a church that is taking an active step in opting in other words, they're saying we want to allow our congregation, our members to have guns, I'm pretty sure they're going to also take an active step in properly notifying anyone and visitors in a very in a good fashion to let them know where they stand on that opt-in provision. It would do them no good to take the active step in opting in and then not let anybody know they can have guns. It would be pointless. So it would seem illogical that they would opt in, take the proper steps to opt in, and then not let anybody know that they've opted in.
The onus is on them to let people know they can bring guns into the church. So
Yes,
if
ma'am.
I go up to a church, I should see a sign that will say, there are guns in this church and I better leave. Is that right?
I don't think it should say you better leave.
Well, that's my personal, that's what I would do.
And that would be your right as a citizen to not go on that private property because you chose not to. But I would think if a church were to opt in, that church would more than likely let everyone know they've opted in. Because
Well, I
if
would think they should be required to let people know. I mean, that ought to be part of the bill. But anyway, that's my opinion.
Ma'am, if you will, we've got a few others that want to answer your questions.
Okay.
Mr. Cook.
Thank you, Mr. Chairman. I'll be brief because Representative Hightower covered most anything. I would just, to further this point, though, it would be no different than your house. If I was coming to your house, you're a private property owner.
I have a sign on my house.
Exactly. You can tell me if I was coming to your house, you know to me.
You're going to have a lot of people dropping out of churches.
Well, the change made in the substitute is actually one erring on the side of caution, but it's still about private property rights. Currently, as a law-abiding citizen, I can't protect myself in a church. This gives my church the ability to allow that to happen or not.
It doesn't give me the right to protect myself from guns.
You don't have to go, and guns don't shoot themselves.
I realize that.
And we have one more. In response to your concern about the honorable discharge, Representative Atwood.
Ma'am, you asked about honorable versus general. I'm on the Senator's bill on line 125. It currently reads honorable or general conditions. I'm prepared to offer a friendly amendment striking or general and simply under honorable conditions.
That's great.
Under the other bill, it has honorable conditions. Under the other substitute, just figured I'd let you know that.
Yeah, I think the general is, there are some problems with that. Thank you.
So the LC 295662 does restrict it to honorable discharge.
It does, Mr. Chairman.
And the Senator's version does not. Very good. Ma'am, were we able to answer your questions? Thank you so much. Yes, sir.
Good afternoon. I'm Rushi Patel with the Georgia Municipal Association, and I'll try to keep it brief as my colleague at the County Association addressed our major concern with the bill. And we have over 500 members with the Georgia Municipal Association, and we don't take positions on firearms bills just like our county counterparts. We do agree that there should be local control. Under current law, firearms are prohibited in government buildings. We do believe that that should be improved and that local control should be granted to local governments and that they should be able to choose from themselves whether firearms should be allowed in those government buildings. And so we agree with our county counterparts on that issue. Another issue which I was able to raise with the author of House Bill 512 previously, and I'm not sure if this is in the substitute presented before you, was in section 1-8, referencing 16-11-173. And it's a belief that there might be some confusion with language in the current law and the language presented here in 16-11-173. There's an expansion here for preemptions on design, marketing, and manufacture of other weapons beyond firearms. We're already prohibited for firearms on that issue, and the expansion here is to other weapons. There was legislation last year that dealt with knives, but provided exceptions as to that part with courthouses and government buildings. And I believe that that might cause some confusion to those two parts. So I don't know if this has been addressed or not, but it's just an issue to raise. And if there's any questions, I'd be glad to take them. Thanks.
Any questions? Thank you. Do we have anyone else who wishes to speak? Yes, sir.
Thank you, Mr. Chairman. John Monroe from GeorgiaCarry.org. We've previously spoken in favor of both HB 512 and SB 101. So from our perspective, the combination of the two remains to be a good bill. So we support the amendments as offered, and thank the committee for its time. And I'd be happy to answer any questions.
Any questions? Any questions of the committee? You have absolutely just wore them out.
Thank you, Mr. Chairman.
Thank you for being here again. Yes, ma'am. Please do.
Yes, I'm trying to understand the distinction. You're saying you're being very concerned about courthouses, protecting courthouses from firearms, but you're not as concerned about public universities, where my child goes, where many of us are children go, public universities. Tell me why you're so concerned about the emotions that occur with people coming into a courthouse situation, but you don't seem to be as concerned about 18-year-olds on campus who may be immature, distraught, upset because they flunked or their girlfriend dropped something. Tell me why. I'm struggling with that.
Well, I think we have a member that might tell you his thoughts. Mr. Hightower.
The big difference for me, and I'm attorney when I'm outside of here, when you go to court, you're dealing with people that may be sentenced to life. You're dealing with people that have, you're dealing with child molesters, rape victims. The emotions there are astronomical. You're talking about children, and I have a child as well, and we care for our children deeply. But there comes a time where they're no longer children, and the law says 18, but we're actually addressing 21-year-olds, because we're talking about people who can carry on campus would be 21 and up. There's a small caveat, there's an exception here, people that can have one 18 to 21 this law passed, dealing with military service. But the general rule is going to be 21 years and older. So you're really dealing with your upperclassmen, even though I think 18, they're old enough to serve our country, which is why I believe that caveat comes in. I don't think they're children anymore. But for the majority, they're going to be 21. The emotion that runs in a 21-year-old's mind because him and his girlfriend just broke up or he received a bad grade is much different than a father having to watch someone who just raped his daughter say that she wanted it because of the clothes she had on, which is in the courtroom. And that's one that we'll just have to have. If someone rapes my daughter and they say that that my emotion's the same as a kid who just got broken up with a girlfriend, our opinions differ very, very vastly.
All right. Ms. Waits.
Mr. Chairman, at the appropriate time, I don't want to delay the public discussion, but I had a question of the law enforcement community. Is this the appropriate time?
If you could tell me which one of the law enforcement community you'd like to talk
Any
to,
will be
I'll
fine.
ask them to speak, come to the front.
Thank you.
Would you like Mr. Norris of the Sheriff's Association?
Yes, please.
He's out in the hallway, Mr. Chairman.
Mr. Chairman, I also want to go on record indicating that I want to state that I appreciate the intent and spirit of both pieces of this legislation and your willingness to perfect the bills. Thank you.
Mr. Norris, we have a committee member that would like to ask you a question. If you might come to the well.
It's a friendly question.
Yes, ma'am.
In this committee, I've heard it raised several times that there's a notion that permit carriers or licensed concealed weapons permit holders or law-abiding citizens. My question to you is this: how do we address individuals who have committed crimes after receiving these permits? And secondly, do you have any information or a method to cross-reference that those individuals who have broken laws and committed crimes, essentially setting us up for a need for a database?
If you're a permit holder
Yes.
in this state, you have had a criminal history background check, and it has not excluded you from having and possessing and being issued a permit. If after you have undergone the background check, you later commit a crime, then your criminal history record, if you're disposed guilty, will reflect that. It would not, at that point, you would not be eligible to possess a firearm, period. Does not address the permit side of it. If someone did commit a crime, and which precluded the permit, and they yet still held the permit would not allow them to carry a weapon. It would just simply mean they had the permit at that particular time. And I don't know if that answers the question. As far as the database, the only database we have to go by is the criminal history record of an individual, which is a fingerprint record, which is maintained by GCIC and NCIC on criminal history records, and that's what we would access.
Is it your belief that there would be a purpose then for having some form of a database?
Well, I think we do have the database on the criminal history. I think that's where we would go first. I mean, I don't know if I answered the question because thank you.
I understand. I think what the answer to the question, if I was trying to follow you on this, was there is no database on those who hold permits. But if someone who is a weapons permit in Georgia, concealed weapons permit, if they have violated the law and if they are adjudicated to be guilty of a felony, then they are in fact under state law, another code section, then they're guilty and are forbidden to have a weapon, or they're charged with a secondary offense. Most probation officers and probation and parole officers and judges are very, very pointed to tell folks, especially in the probation or the paroles act, that once they're dealing with an offender, then they tell them you cannot, by Georgia law, be in possession of a firearm even on the premises of where you live. Thank you, ma'am. Thank you, Terry.
Yes,
do we have any other? Yes, ma'am.
Thank you very much for taking my question. My voice is not great, but I really appreciate this committee eliminating the portion of HB 512 about opening up or reducing the restrictions on bars, because as we know, drinking and firearms have a very dangerous link to each other. However, in university campuses, there's also a lot of drinking going on there. And there is there is a Department of Justice report that that shows that the surrounding area around a university campus is has much more crime and gun violence than in the university campus. And also, the entire Board of Regents and every university in the Georgia system is opposing this portion of the bill. So it would seem to me that these folks know what they're talking about, and there's data available to show that this might be not in the best interest of our children. So I would like to ask, have you taken this to account, and where are you coming from that you feel that this will make our children safer?
Are you addressing that to the committee or to the authors of the bill?
whoever chooses to answer, whoever is responsible for that portion of the bill.
Well, then I guess everybody could answer. Ms. Jaspers, would you like to address first?
Just real quickly, just like you said, the area that's around a college campus has higher rates of crime. And that's specifically why we're looking at this. Because what we have done by eliminating any weapon from a campus is we've created a criminal empowerment zone where the criminal has more rights than the student, where they're not unable to defend themselves. And you have to recognize that today many students don't live on campus. They live just off campus. They park off campus. They walk throughout the campus. And then today's untraditional student does it all hours of the day and night. And our change would allow them the opportunity to protect themselves. Because I don't know if you're in an earlier testimony, this fine group has listened to hours of testimony. And the one that struck me the most, that stuck with me through all the hundreds of conversations I've had, is though we believe our security on our campus is doing the best job they can. But repeatedly, over and over, during a committee meeting we had, they said that they could be anywhere in 3 or 4 minutes. And for those of us, and my family's one, 3 or 4 minutes is all it takes. So we're doing this for them. Thank you.
All right. Any of the committee members wish to follow up with that? No.
Can I just reiterate that the data shows that it will make it less safer? That's my own point, and I would like you to consider that. I will be happy to send you the data from the Department of Justice.
Thank you, ma'am. Now, do we have anyone else who wishes to be heard, either for or against? For or against? All right, so before we move forward, I want to make just a comment to the ladies that have spoke on the church issue, and I'm just going to give you my opinion from the numerous emails and phone calls dealing with churches by opting in. The churches and the religious schools that we have heard from, I have no doubt that they'll put a sign up in front of their place, in front of their church. I mean, the hardest thing that I had to deal with in the whole process of this was in my mentality, and that was people carrying guns into a church. I'd always viewed it as a sanctuary. But all of these emails, and we got them from religious colleges, I got them from churches, from ministers who said that they had no problems with people bringing it to their church. That being said, those would probably be the churches that it would be known, and I don't think that would be a problem. On the campus carry portion of this, I can understand your concerns if you believe in the Second Amendment. The Second Amendment was for a purpose, and that's for people to protect themselves. I don't think you're going to see any more weapons at a lot of these campuses, but I do think that in the case of some of these urban campuses, with the crime rates at Georgia Tech of students going to and from their classes, I think that it might be a possibility that those students might use them on the urban, might take a weapon on the urban campus. And then again, I'll go back to the whole premise of all of this. We're talking about the age of 21, majority consent, except for the exception for honorably discharged young men and women. 21, no felony convictions, the criteria on the mental health type screening that we put the preponderance on involuntary commitments and the such. This is a cleanup in this type of language. So, you know, there's nothing perfect. I am continually concerned about the reading of the Second Amendment, but I think it says it is what it says, that you have a right in this legislation that has been proposed and passed the House, that people have a right to go on property. That private property owners, then they can exclude people with weapons, and that's pretty well open. Courthouse language has been an attempt to clean up the government buildings and all of this. Now, that's pretty well the gist of what, since everybody else has chimed in, I wanted to address your concerns on that. At the end of the day, laws of nature tell people that they have a right, they have an instinctive, born right in their system to protect themselves. And I think that's where the gist of this comes from. Now, that being said, if there's no other questions from the committee and no one else that wishes to be heard, then we're going to move to the process. We have two substitutes in front of us. Out of courtesy to the senator, who is the author of the bill, Senator Gann, he has proposed a substitute, LC 3530004S. From the House side, there has been proposed LC 29566 ERS. What is the will of this committee?
Mr. Chairman, I would at the committee's recommendation on line 125.
This would be under your...
Under LC 353004S.
Yes, sir.
Strike or general conditions. Just striking the or general.
All right. At the proper time, one of the committee members may make that. First, the committee has got to decide which one of these. So at this point, I'm going to ask, under LC 353004S, do we have a motion? Do we have a motion? If not, dies for lack of a motion. On LC 29566 ERS, do we have a motion? We have a motion. We have a second. Any questions on the committee substitute? At this time, I'm going to introduce an amendment. Pass them out. Give the committee a minute to look at this, and I'm going to explain this amendment to the committee substitute that has been agreed upon. This was a couple of the issues that were in the original SB 101 that has been perfected with cross language to the current Georgia code. This amends the substitute to prevent the creation or maintenance of databases regarding persons issued weapons carry licenses, and to provide for the verification for law enforcement personnel. Also, by inserting a person or entity shall not create or maintain a multi-jurisdictional database of information regarding persons issued weapons carry licenses. The judge of the probate court or his or her designee shall be authorized to verify the legitimacy and the validity of a weapons carry license to a license holder pursuant to a subpoena or court order, or for public safety purposes, but shall not be authorized to provide any further information regarding license holders. The purpose of these is to prevent databases that might get into the wrong hands, that would jeopardize those license holders and people exercising their Second Amendment rights to own firearms, and also to prevent any public disclosure as to who has a weapons permit that might at that point make it a dangerous proposition under a Freedom of Information Act of who owns permits. The bad guys, as they say, if they could get a hold of that information, they might very well know whose homes to target. And we thought that was an excellent proposition. We just need to clean it up a little bit from the NRA language. And that is the amendment that I offer in front of the committee. You've had time to look. What would be the wishes of the committee? We have a motion to accept the amendment. We have a second. Any questions about the amendment? No questions? If not, all in favor say aye. Aye. Opposed? The amendment is adopted. Now we move to the full body of the committee substitute as amended. What is the wishes of the committee? We have a motion. We have a second. We have an amendment properly passed. Any questions? Any other amendments? Ms. Waits.
Mr. Chairman, I have another question.
Yes, ma'am.
And this is simply a friendly amendment, similar to those found in Section 74 through 75, 81 through 82. And this is simply to allow each institution to decide this matter, given the fact that experts from the law enforcement community as well as college administrators have adamantly opposed this legislation. Will we be open to an opt-in for each institution?
I beg your pardon?
An opt-in piece to which that we can allow each institution to make these decisions
As a
independently.
committee member, you are certainly welcome to make that amendment.
Thank you, sir.
If you're prepared to do so.
Yes.
Then make your amendment.
Yes,
State
I'd like
your
to.
amendment.
Thank you, sir. I'd like to offer an amendment that each institution will be able to individually make these decisions per institution.
Do you have the lines? If you might, Ms. Long, of council, could you maybe assist in this?
I think we would start here under 226, page 7, somewhere in there. An opt-in opportunity for each institution to make that decision as to whether a student would be permitted to carry a weapon.
We'll give council just a second so that
I don't believe that I can word an amendment clearly based on the information I have in the home.
Something very similar to what you see in section 74, 75, 81, 82.
I think where she is saying, Representative Waits is saying on the campus care language, it starts on the substitute on line 226. That's the section that deals with campus carry. She's wanting to do an opt-in provision. Is that correct?
That is correct. Something very similar to what you have under section 74, 75, where it says unless the administration of such permits the carrying of a weapon. Very similar to 81, 82. Correct. Forgive me, line. Something similar to an opt-in.
Council, I think what she's using is a reference to the opt-in language on line 74, 75. She's using that as an example.
Yes.
To add to the campus carry that starts on 226.
I understand that, but this code section is extensive and complex. I hesitate to amend one line without reviewing the entire language to make sure that we're adequately doing that. I mean, I'd be glad to do that.
Let me see if I can make this a little bit easier.
Thank you, sir.
What you'd like to do is on the campus carry portion.
Correct.
You would like for this to be an opt-in provision as
Yes.
opposed to being able to, a weapons permit holder,
Absolutely.
to be able to take that weapon on those restricted areas that we have said, basically the campus from vehicle to the classroom.
Correct.
No dorms, no fraternity sorority houses, no athletic events. But to be able to take that for a weapons license holder, that this would have to be at the permission of that university.
Correct.
Now, the next question I would ask is, who would set that permission? Would it be the student body? Would it be the student council? Would it be the president? Or would it be the Board of Regents?
I'm not sure. I mean, my assumption would be whoever has the authority to make such decisions.
I mean, we would need to have, to perfect your amendment, we would need to do an opt-in provision, but someone would have to be, there'd have to be some specific language.
Okay.
Of who would be the responsible party.
At this point, given the hour, I would simply say the Board of Regents.
All right. So it'd be opt-in at the quote Board of Regents and the director of the, is it director? Is that the proper title for the technical vocational schools? Commissioner of
Public safety.
GTAE.
And Mr. Chairman, I simply offer this amendment for one reason. Here in committee, it was raised that with respect to Second Amendment rights, that there is a belief that you don't need to know how to operate a weapon, load a weapon, shoot a weapon, to have a concealed weapons permit here in the state of Georgia. So I simply offer that as another layer of protection for the students who are in these institutions. We will have individuals walking around with weapons who cannot operate them, who do not know how to unload or shoot them. And I find that disturbing.
Any comments from any of the committee members? Anyone want to chime in to help Representative Waits with her motion? Well, I tell you what, you're the author of the proposed amendment. Would you like to restate how you would like this at the option of council properly drafting this?
Yes.
Then we can put it up to a vote to see what the committee feels like.
The motion, sir, is to allow each institution to decide this matter individually. The Board of Regents would have oversight, as well as their law enforcement or public safety division.
Both college and technical schools.
Yes, sir.
All right. We have a motion. We have an amendment offered by Representative Waits. Do we have a motion to accept? Do we have a motion to accept? Sorry, it dies. Very good. All right. Do we have anyone else who wishes to offer any amendments to the substitute 295662 ERS? No other amendments? Then the proposition before you is the committee substitute as amended. We have a motion. We have a second. It is now perfected. No last questions? No comments? If not, all in favor say aye. Aye. Opposed? You wish two? Two opposition? Very good. Then the ayes clearly have it, and this bill moves forward. Thank you, ladies and gentlemen, for being in attendance today, and thank the committee.
If I might ask a question before you adjourn. On the original Senate Bill 101 had in section 5 on page 4, lines 124, 125, there was particular language that repealed some of the state requirements regarding firearms dealers in Georgia.
Yes, sir.
And I was looking for that in the substitute, which y'all are in the process of passing, and wanted to see if it was in there, and I couldn't find it, and I was asking for if one of y'all could.
Senator, this vote has been taken, but let me give you this information from the substitute. There was 3 sections. I think there were 3 or 4 sections that were added into this from your original 101. And I'll start with the preempting a ban on firearms in public housing. After talking with council, one, that is already covered under federal statutes. And the other concern that gave a more broader concern to the chair was that it being not of the same germaneness, that it would put this bill in jeopardy, according to legislative counsel. Number 2 was the issue that dealt with duplicative state required licensure. I don't think any of the committee really had a lot of information on that. So at some point you might want to try to, get some other information to that. And then, of course, the reciprocity issue was something that there was still some concerns.
Yeah, thank you, Mr. Chairman.
And I'm sure we'll probably visit these again at some point.
I will. We'll look forward to working and passing a good Second Amendment's right gun bill with you.
I would like to thank, on behalf of this chair, would like to thank both of you gentlemen for your work, your diligence of promoting the Second Amendments, and I look forward to working with y'all on this a little bit further into detail. Good job, guys.
Thank you, Mr. Chairman.
Thank you, ladies and gentlemen. I ain't gonna blindside the senator.